Hey in-laws, welcome to the Jackie Law Review. I have been waiting to do this video and I feel like now is the perfect timing. This video is about the YSL trial. I'm going to get into what I think are the top 4, the wildest moments that have happened so far. I feel like a part 2 is going to be necessary, even a part 3. But for right now, check out my top 4 moments. Let's go.
I'm Jackie. I've been a licensed attorney and commercial litigator for over 10 years. I'm a pop culture junkie, and I know stuff. Welcome to the Jackie Law Review. Let's go!
Coming in at number 1, I was trying to figure out how to do this because he has many moments throughout this trial. So I did my own little compilation of some of his just wildest moments. Just check these out.
And Mr. Copeland, good afternoon. Do you want to be here?
Ma'am?
Do you want to be here?
I'm here.
Okay. Are you going to let me ask you some questions?
Okay.
How old are you?
Grown.
Okay, what does grown mean?
I'm an adult.
Okay. And when you say you're an adult, what number in years are you?
I plead the fifth.
Has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes, sir. Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She fired.
She's fired? Okay.
Wow.
Did you tell police that Thug had an issue with Rich Homie Quan bringing members of If Gang to his condo?
Again, when I'm talking to the investigators, I'm going to tell them anything to get them off of me. But as I sit right here, I'm telling you the God and the truth that Thug, I had an issue with Rich Homie through threat. And about my partner, whatever he with, I'm with. They don't have nothing to do with YSL. Y'all trying to make it seem like this has some, just because they don't have nothing to do what I do and what threat do, they don't have nothing to do with YSL.
I still don't think I heard an answer. Did you tell police that Thug had an issue with
I think I
Rich
just answered
Homie
you.
Quan? I don't think you did. Oh, if you did, I did not hear you. So
Oh,
you
I'm
could
sorry.
repeat your answer.
I said that Thug was trying to protect Rich Homie. He was calling us saying that, man, hey, man, leave Rich Homie alone. Like, he don't tell me what to do.
So that still didn't answer the question. Yes, no, I don't recall. Did Thug have an issue with Rich Homie Quan bringing members of If Gang to his apartment?
Thug, did you have an issue with Rich Homie?
I'm asking you for what you told the police.
And I'm answering you. I just told you several times. I tell the police anything.
Okay.
Where's the witness prep?
He fired his lawyer. He talked to a defendant in the case, Young Thug. He's like, hey, Young Thug, what? Side note, Woody is a star now. He's like a celebrity. He's been on the pop dating show, The Balloon Show. He's on that.
You innocent? I said, what you do though? Like, what you do? What you do for a living?
Go to jail.
You went to jail? How long was you in jail?
Which time?
How many times you was in jail?
Too many to count.
Coming in at number 2. So this case was originally signed to Judge Glanville. This next clip is going to show him getting into it with Young Thug's attorney Brian Steele. Now, just a little background on this clip. An ex parte communication is one between a judge and one of the parties in the absence of the presence of the other party. And you can only do that within very confined restraints, right? You're not supposed to, the judge is not supposed to just be communicating information or anything to just one side. That makes sense, right? That could show an appearance of impropriety. It could show bias, right? So it makes sense that on all communications with the judge, everybody has to be aware. So as a background to this clip, Brian Steele, attorney for Young Thug, heard that there was an ex parte communication where he wasn't present and none of the other lawyers representing any of the other defendants were present. It was just the judge and the prosecutors and Woody.
Is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never...
Mr. Steele, can I interrupt you for just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to ask you the question.
Okay.
Scuttle, if you look at SCUDDER versus State, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somewhat accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me, and you and Mr. Adams meet with me, and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said...
And you haven't answered my question yet.
I'm not going to answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this information?
I'm not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have this. I have problems right now.
Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
Or
proprietary?
information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why?
Sir, I'm going to hold you in contempt if you don't tell me who tell me who this information was from.
I don't want to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I tell you
what, I'm going to give you 5 minutes. If you don't tell me if you don't tell me who it is, I'm going to put you in, I'm going to put you in contempt, because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue.
You got 5 minutes?
This is what I was told. Mr. Copeland,
recess.
Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No.
It's fascinating. So in that clip, you could see Judge Glanville, instead of, I guess, speaking to the actual substance of the meeting and dispelling any thoughts that there was some bias that occurred, his main concern was, who told you? He kept asking, who told you? How did you hear? Who told you? I'm like, this is crazy. This is crazy. Needless to say, he held Mr. Steele in contempt, and he sentenced him to be he wanted him to be in custody at the Fulton County Jail for, I think, 10 weekends or something like that. He wasn't, held in jail. I think his wife bailed him out or something like that. His wife, who's also a lawyer, bailed him out. And whoever heard the hearing on his bail agreed that he needs to be present to represent his client who's on trial. His motion to have Judge Glanville recused from this case was heard. To no surprise, after this exchange and after this whole ordeal, Judge Glanville was ordered to recuse himself from this case. He was removed from this case, and it was transferred by random appointment to a Judge Ingram. Less than 24 hours from when this case was transferred to the Judge Ingram, she recused herself because she had a prior professional, not personal, relationship with one of the deputies. Apparently, it's the same deputy that was caught passing something to Young Thug earlier in the trial. What is Atlanta, answer for yourselves. What say you? That deputy happens to have been Judge Ingram's deputy. So she recused herself from the case. That's judge number 2. So the case has now been transferred to Judge Paige Whitaker. So she is now the judge of this trial. She's known as a no-nonsense judge. She doesn't like to take breaks. She wants trial every day. So it's interesting that she also finds, which I'm going to talk about later, the prosecution's style of their courtroom style is just strange, to say the least. But that's neither here nor there. I'm going to get to that later. Another highlight of this case, one of my favorites, is when Young Thug's song Lifestyle was played in court. Now, granted, it wasn't played in front of the jury, but it was still, we were jamming. And imagine the restraint. I'm going to play this clip, and you're going to see all the defendants, everybody in that courtroom. I know they wanted to dance. But imagine the type of restraint that was displayed in this next clip. Watch this.
Come on, go ahead and play, sir.
Rich gang, baby. Got 4 ounces in the 20 bit. Did a lot of shit just to live this here lifestyle. Time for a nigga, hey, Quan boy. Ain't gonna feel nothing on my niggas say. No way. Nigga couldn't see me if they had a genie. I'm living my life like Beanie. I repeat my brother Beanie. I stack no right to the ceiling. Now these niggas can't beat me. I check my wake up one Chanel and these bitches can't see me. I'm in the whole.
So you would think that it was the prosecution that wanted to actually play the video, the lifestyle video, to show something, to show hey, look at Young Thug and his people's lifestyle and see what they do. Actually, it was Young Thug's lawyer who wanted to enter that video into evidence. He says that in the indictment, there was a picture attached to the indictment that had a photo of Young Thug in a shirt that had RG on it. And he wanted to show that RG stands for Rich Gang, and it's their musical group. And as you can see, the musical group in this video. He also said that he wanted the video to be entered as evidence to show that apparently, I think a lot of people kind of know that YSL is alleged to be an affiliate gang of the Bloods. And so he wants to show that in this video, there are a lot of people wearing red, but Young Thug isn't one of them. I don't know that that's what that proves, sir. The state objected to Attorney Steele's motion to have this entered as evidence, and the judge was saying that he was going to sustain their motion just based on the actual individual that Steele wanted to lay the foundation for the video. Judge Glanville said he was choosing the wrong person. Anyway, here we are. They went back and forth, and as of now, it's still unclear whether the video will be entered in the evidence and whether the jury will hear it. My last of the top four. This is again just going to be my part one. I just know that there's going to be other parts of this, but number 4 is the moment that Judge Whitaker, now the third judge that is now trying this, that is overseeing this case, Judge Whitaker goes off on prosecutor Adrian Love. Now, let's talk about courtroom style. I think every litigator has different courtroom styles as it relates to what venue they're in. And so take me, for example. I have a different courtroom style in state court versus federal court. When I'm in state court, I have a different courtroom style as it relates to even the different counties within the same state. So everybody has a different way of delivering information to the jury. I will say that the prosecutors in this case have an interesting courtroom style, and it's annoying everybody. And so number 1 rule is don't annoy the jury, at least. But we can see from this next clip that I'm about to show that the judge is annoyed. Let's watch.
Everything that was on the right side, all of the verbiage to be, I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse. It is what it is. I think that the state was disingenuous about it. State's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that. But this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes.
Y'all, I can imagine if a judge went off on me like that. I don't even know what I would do. So there's some background. Now, this actual exchange was due to a specific piece of evidence, right? Apparently, the state wanted to enter an Instagram post as evidence. They had a private talk. The prosecutors and defense counsel had a private talk. They approached the bench and talked to the judge privately, where defense counsel rose an objection to the captions and the things that were outside of the actual photo in the Instagram post, and said that those captions, those comments were hearsay. Prosecution agreed, judge agreed. They said that they would enter the evidence, just the photo, and not ask any questions or even refer to the captions. What does Attorney Love do? She refers to the caption. She refers to the captions. And so that's why the judge was upset. That's why defense counsel filed a motion again for mistrial. There have been so many motions for mistrial. The judge has denied all of them, But this was the reason for yet another one where Attorney Love said that she was going to do something and she does the exact opposite. That's why Judge Whitaker goes off. I don't know. I feel like I've been following this case. And to be fair, Adrian Love has a way of belaboring a point and taking forever to get to the meat of the case. So you as the state, you know that you have a gajillion witnesses to call. This is actually the longest trial in the history of Atlanta. So you have all these witnesses to go through before defense even puts on their case in chief. And yet you're asking witnesses questions like, how many brothers and sisters do you have? Like, girl, get to the point. Get to the point. Get to the point. So as of today, trial is still sticky. There have been several, I think every single, there are a lot of defendants, right? And I think every single attorney for each of the defendants has moved for a mistrial at least once. And the judge is, there have been statements that the judge is basically cleaning up prosecution's case for them and denying these motions for mistrial just to avoid all this money spent on putting on this trial that just seems very haphazard. But now there's been yet another motion for mistrial based on the jury hearing another piece of evidence that they shouldn't have heard in the first place. I've been following this trial, like I said. I don't know how many times the judge has instructed the jury already to ignore something that they've heard. And one of the famous sayings of any defense counsel that's trying to move for mistrial is, you can't unring a bell. They've already heard something that you don't want them to hear, or they've already seen something that you don't want them to see, and you're instructing them to ignore that. So we'll see how this goes. Nevertheless, I'm about to listen to Lifestyle. I'll catch y'all later.